Is police permission necessary to organize a protest against the government? Hello friends. Welcome to my YouTube channel, Legal Information Law Insights. I am Advocate Mukund Mahajan. Today's topic is extremely important because it concerns one of the most important rights in a democracy, the right to peaceful protest. Whenever citizens organize a protest, rally, march, demonstration, or public meeting against a government policy, several questions arise. Is police permission compulsory? If permission is not obtained, does the protest automatically become illegal? Can the police refuse permission simply because the protest is against the government? And if permission is refused, what legal remedy is available to citizens? Let us understand the legal position on the basis of the Constitution of India, the Bharatiya Nagarik Suraksha Sanhita, 2023, or BNSS, and important judgments of the Supreme Court. Constitutional right to protest. The Constitution protects two rights that are particularly relevant here. Article 19, 1a, guarantees freedom of speech and expression. And Article 19, 1b, guarantees the right to assemble peacefully and without arms. Therefore, citizens have the constitutional right to express their views and to peacefully assemble to support or oppose government policies. But these rights are not absolute. Article 19, 2, permits reasonable restrictions on freedom of speech and expression on constitutionally specified grounds, including public order. Article 19, 3, similarly permits reasonable restrictions on peaceful assembly in the interests of the sovereignty and integrity of India and public order. Therefore, the Constitution protects peaceful dissent, but it also requires that such dissent be exercised within the framework of law. Is police permission mandatory for every protest? Now comes the main question. Is there one central law which requires police permission before every protest in India? The answer is no. There is no single central law making prior police permission compulsory for every protest throughout the country. However, this does not mean that citizens can organize a rally or demonstration anywhere and at any time without complying with applicable law. Depending upon the state and the location, police acts, municipal laws, local regulations, traffic rules and administrative directions may prescribe requirements relating to public meetings, processions, rallies and demonstrations. For example, authorities may regulate the venue, the timing, the route of a procession, crowd size, traffic arrangements, and public safety measures. The purpose of such regulation is to protect public order and the rights of other citizens. Therefore, we must understand the difference between regulation and prohibition. The authorities may regulate a peaceful protest in accordance with law. But the mere fact that the protesters are criticizing the government does not, by itself, justify an arbitrary prohibition. The Supreme Court has recognized this distinction in several important judgments. What if there is no permission? Another common question is, if people hold a protest without obtaining permission, does that automatically make the entire protest illegal? The answer is not necessarily. The legal consequences depend upon the applicable local law and the circumstances of the particular case. For example, authorities may take action if protesters violate a valid legal requirement, disobey a lawful prohibitory order, obstruct public roads unlawfully, create serious public disorder, or engage in violence. Therefore, citizens should not assume either that permission is always constitutionally mandatory or that permission can always be ignored. The correct approach is to examine the applicable law governing the particular place and proposed demonstration. BNSS 2023 and preventive orders. Let us now come to the Bharatiya Nagarik Suraksha Sanhita 2023, which replaced the Code of Criminal Procedure from 1 July 2024. An important provision is Section 163 of the BNSS. It empowers an executive magistrate to issue an order in urgent cases involving nuisance or apprehended danger, where immediate prevention or speedy remedy is considered necessary under the circumstances specified in the section. Such preventive powers can become relevant when there is a genuine apprehension of disturbance of public tranquility, danger to public safety, or other circumstances covered by the provision. But Section 163 does not mean that every protest can automatically be prohibited. Any restriction affecting fundamental rights must remain within the Constitution and the law. The BNSS also contains specific provisions dealing with the dispersal of assemblies, including Sections 148, 149 and 150. Therefore, the legal position is not simply that police can stop any protest. The real question is whether the authorities are exercising their statutory powers lawfully and for a legally permissible purpose. 4 important Supreme Court judgments. 1. Himmat Lal K. Shah v. Commissioner of Police 1973. The first important judgment is Himmat Lal K. Shah v. Commissioner of Police. The Supreme Court recognized the constitutional importance of public meetings and assemblies. At the same time, the court held that public streets and public places are used by everyone and therefore the state can regulate assemblies in the interest of public order. The state can therefore impose reasonable regulations concerning the time and place of a meeting. But regulation cannot become an arbitrary method of suppressing the constitutional right of assembly. In simple words, the government can regulate a peaceful protest, but cannot arbitrarily suppress peaceful dissent. The Supreme Court has subsequently referred to this principle while considering the requirement of prior permission for public meetings. 2. Ramlila Maidan Incident v. Home Secretary, Union of India 2012. The second important judgment arose from the events at Ramlila Maidan, Delhi, in June 2011. The Supreme Court examined the police action used to disperse the gathering. The judgment is important because it demonstrates that the state's duty to maintain law and order does not mean that authorities have unlimited power to interfere with fundamental rights. Police action affecting peaceful protesters must have a lawful basis and must be justified by the circumstances. The case therefore reinforces the principle that state power must be exercised with restraint, accountability and regard for constitutional rights. 3. Mazdoor Kisan Shakti Sangathan v. Union of India 2018. The third important judgment is Mazdoor Kisan Shakti Sangathan v. Union of India. The Supreme Court considered the relationship between the right to protest and the rights of other citizens using public places. The important principle is that the rights of protesters and the rights of the general public must coexist. A peaceful protest cannot be treated as completely unrestricted simply because it is protected by Article 19. The administration may therefore regulate demonstrations so that public roads and public spaces remain reasonably accessible to everyone. Thus, the constitutional objective is balance, not suppression of dissent. 4. Amit Sahni v. Commissioner of Police 2020. The fourth important judgment is Amit Sahni v. Commissioner of Police, popularly known as the Shaheen Bagh case. The case concerned the prolonged occupation of a public road during the anti-CAA protests in Delhi. The Supreme Court recognized the right to peaceful protest but also made it clear that public roads and public spaces cannot ordinarily be occupied indefinitely in a manner that seriously affects the rights of the general public. The court therefore emphasized the need for protests to be conducted at appropriate locations rather than causing indefinite obstruction of public ways. The important message is: the right to protest is constitutionally protected, but it does not create an unrestricted right to occupy every public place indefinitely. What if police refuse permission? Now suppose citizens propose a peaceful protest and the police or administration refuse permission. Is there any remedy? Yes. If the refusal is alleged to be arbitrary, unlawful, discriminatory, or inconsistent with fundamental rights, an aggrieved person or organization may, in an appropriate case, approach the High Court under Article 226 of the Constitution. Where the requirements of Article 32 are satisfied, the Supreme Court can also be approached for enforcement of fundamental rights. The court may examine whether the restriction has a lawful basis, whether there is a genuine public order concern, whether the restriction is reasonable, and whether the authorities have acted within their legal powers. Therefore, refusal of permission is not necessarily the end of the matter. 5 simple legal principles. Let us now remember the entire discussion through 5 simple principles. First, peacefully criticizing the government or opposing its policies is not, by itself, a criminal offense. Second, the right to peaceful and unarmed assembly is protected by Article 19, 1b, and freedom of speech and expression by Article 19, 1a. But both rights are subject to constitutionally permitted reasonable restrictions. Third, there is no single central law requiring police permission for every protest throughout India. However, applicable state laws, local regulations and lawful administrative requirements may require permission or compliance with prescribed procedures. Fourth, authorities may regulate the venue, timing, route and manner of a protest to protect public order and the rights of other citizens. But regulation should not become an arbitrary prohibition of peaceful dissent. Fifth, if a protest becomes violent, seriously disrupts public order, damages public property, violates a valid lawful order, or creates a genuine threat to public safety, the authorities may take appropriate action according to law. Conclusion. So, is police permission necessary to organize a protest against the government? The legally accurate answer is: there is no single central law making prior police permission compulsory for every protest throughout India. However, depending on the state, location and nature of the proposed demonstration, applicable laws and administrative regulations may require prior permission or compliance with specified conditions. At the same time, citizens have a constitutional right to peacefully express dissent and assemble without arms. The government has the duty to maintain public order and safety, but that power cannot be used arbitrarily to silence peaceful criticism. Therefore, the constitutional balance is very clear. Citizens must exercise their right to protest peacefully and responsibly. Authorities must regulate such protests lawfully, reasonably, and fairly. A democracy becomes stronger when citizens can express dissent without fear, and when state power is exercised within the limits of the Constitution. That is the true balance between fundamental rights and public order. Thank you for watching this video. If you found this information useful, please like this video, subscribe to the channel free of cost, and share this video so that more citizens become aware of their constitutional rights and legal responsibilities. If you have any questions relating to protests, police powers, fundamental rights, the BNSS, or any other area of Indian law, please write them in the comments section. For more authentic and simplified legal information, do not forget to press the bell icon so that you never miss our upcoming videos. Jai Hind! Jai Bharat!